Hello, everyone, and good afternoon. I'm immigration attorney Yael Brudner, coming to you guys live from sunny Southern California. We're live today on Facebook and on YouTube. Happy to answer your immigration questions. Thank you for everyone that sent us questions this week. We have a bunch of really interesting questions to answer today. I think it'll be interesting for a lot of folks. If you are watching live today, feel free to write your question in the comments, and I promise to try to get to it. And if you're watching the replay, also please feel free to write your questions, and we promise to respond. As always, the answers today to these immigration questions are general information. It's not legal advice, but we are happy to give you individualized legal advice if you're interested. So if you are, feel free to contact us. Okay. So let's jump into some questions that we received this week. Let's see. Okay, so the question is, what is the VAWA process? Can you explain? We get a lot of questions about VAWA because I do talk about it a lot on YouTube, on TikTok, in my videos and reels, because I think it's very important for people to know about this very, very important option. VAWA stands for Violence Against Women's Act, and it's a law that's existing here in the United States that allows for a special route for individuals that are close family members to U.S. citizens or green card holders. And these individuals, it allows for them a special route to get their green card by themselves, to self-petition for their green card, which is a very powerful tool. Usually, in order to become a lawful permanent resident, to get a green card, you would have to have someone petition you. In the family-based immigration world, you would have to have a close family member petition you. However, VAWA provides a special route for you to petition yourself without having to rely on a specific family member. Okay, so who would be eligible for VAWA? In order to be eligible for VAWA, you have to be a close family member to a U.S. citizen or to a green card holder. So you would have to be the spouse of, or the parent of, or the child of a U.S. citizen or a green card holder. And you must have suffered from your relationship with this U.S. citizen or green card holder, suffered either extreme cruelty or abuse in this relationship. It could be either or, it could be both. Okay. And when we talk about abuse, a lot of people think that you have to necessarily have physical abuse, but there are a lot of different kinds of forms of abuse. And extreme cruelty, extreme behavior towards you by your close family member, for the most part, is enough to qualify for VAWA. So it is my mission and my passion to talk about VAWA as much as possible so that people can know about it. And if people are in a situation where they feel that they cannot, that they're not in a healthy relationship, they can take the control in their hands and they might be eligible to self-petition. So if this is relevant to you, please call us, schedule a consultation so we can evaluate your specific case. Okay? Awesome. Let's see, I have some questions here. Okay, so I see some questions coming in here also from Facebook and on YouTube. Adrian, it's a specific question. Let's discuss this. Maybe you can contact me in person and we can discuss this further. Okay, let's see. We have another question here. So there's a question here about, I'm gonna just pop it up here. If an individual in the Philippines has been emotionally abused by her husband, can her petition be expedited? Well, I would have to talk to you or your mom further to figure out where exactly the emotional abuse happened. If it happened in the United States, Were they living together? There's certain requirements that you have to comply with in order to qualify for VAWA. So please reach out to us directly, and I'm happy to evaluate. Okay. And this is how you can contact. But thanks for the question. This is a related question that came in. My spouse petitioned me, but we are now having problems and she doesn't want to come to the interview with me. What can I do? Okay. So if you are in the middle of a marriage case, a regular case, right? Regular, quote unquote, you have a spouse, your spouse petitioned you, and you're in the middle of the process, well, perhaps towards the end because you're already at your interview time, and then something happens in the relationship, you're having problems, and your petitioning spouse no longer wants to help you out. They don't want to help you out with the process. They don't want to help you become a green card holder. You have options. You have things that you can do to take the power back and to perhaps self-petition. So in this case, I would have a conversation, would love to have a conversation with you to see what happened in the marriage, what kind of problems, have you been suffering from extreme cruelty or abuse by your spouse? If you have and you feel that this is something that's relevant, then what is available for you would be to switch the regular petition to a VAWA petition. Okay, and basically change the course of the green card process. Instead of applying for the green card based on your spouse's petition, you would switch it to apply for the green card based on your own self-petition. Okay, so this is really important. Not a lot of people know about this. It's available. Okay. Perfect. Okay. Hi, Osama. Thank you for asking a question. I have a question here in Hebrew that they're asking about what are the possible ways to immigrate to the United States, through school, or, what are the ways you can do it? So it's a super general question. I'm not going to answer in Hebrew today. Because this is in English, but feel free to schedule a consultation and we'll be happy to do it in Hebrew one-on-one and kind of explain all the options to immigrate to the United States. Okay. In large, kind of like generally speaking, usually you would have to have a petition in order to immigrate to the US. Someone would need to petition you, either a close family member that's a US citizen or green card holder or an employer. Okay. In certain cases, you can self-petition, but we would have to evaluate that further. Okay, so thanks for the question. תודה. בבקשה תיצור איתי קשר ישירות. Perfect. Let's see. Checking out the questions here. Okay, so Christine is asking a follow-up question. Can I submit the I-130 and the 45 here in the US while your mom is visiting on a tourist visa? Okay, so can you apply for your green card if you came here on a tourist visa? That's pretty much the question. The answer to that is that it depends on the circumstances. Okay, if you come in as a tourist and you came in legally, went through the port of entry, you have a stamp that you were admitted, and then you change your mind and you say, I would like to stay here in the United States. Okay, I never want to go back to my home country. I intended to come as a tourist, but then, you know what? It's really great here. I don't want to go back. I want to live here forever. I have a U.S. citizen child that can petition me, or maybe U.S. citizen spouse. If that's the scenario, generally speaking, yeah, you can apply for your green card here. You can apply to adjust your status in the United States, okay, without leaving. So I hope that answered your question. Okay. Thank you, everyone, for joining today. I see some folks on YouTube and on Facebook. If you have any questions, please feel free to write them in the comments, and I'll try to get to them as we go. And then if you're watching the replay of this, also please feel free to write your questions in the comments. Claudia is asking if COVID vaccines are still mandatory. Okay, so COVID vaccines are mandatory in order to get a green card here in the United States. That's still the requirement. In order to get an exception, There's basically two ways you could do it. You can do it through a doctor that would certify that you have a medical reason why you cannot receive the COVID vaccine. Or if the reason that your preference is not to receive the vaccine is perhaps you don't want to for different moral reasons, you would have to file for a waiver. My experience is that it's tough. It's very tough to get a waiver of the COVID vaccine. The process of getting it through the doctor, they really want the doctor to specify specifically what is the reason why you cannot medically get the vaccine. And then if you're looking at moral, religious reasons, then they really want you to go through a waiver process, which is expensive and lengthy. So from my experience, COVID vaccines are still mandatory and they're hard to get an exception. Okay. Let's see. Okay, so this is a question that came in earlier this week. My husband is here as a tourist. Does he need to go back to his home country to get a green card? So this is super common. This question just came in a few minutes ago, and it happens a lot that people ask us these questions. So if you come in as a tourist and while you're here, change your intent and you decide that you do not want to go back to your home country, and you have a qualifying family member that can petition you, like, for example, a U.S. citizen spouse in this example, then you definitely can apply for your green card here in the United States. Okay, generally speaking, what you would do is you would file a green card petition and an application to adjust your status here in the United States. Okay, the first requirement is that you entered legally and were admitted at the border. So coming in as a tourist satisfies that requirement, and can absolutely do it. I definitely recommend having a lawyer to advise you about this. When is the best time to file? Other considerations to take into account. This is kind of general information. Technically and generally, yes, it's possible, but I always recommend talk to a lawyer to evaluate your specific circumstances. Okay. Awesome. Okay. So Adrian's asking, can my wife still be petitioned if we decide to live in the Philippines? So let me see for a second. Okay, Adrian, I'm just following up on your first question because this is kind of a second question. Okay, so you can go through the process of filing for your wife in the Philippines. So the green card process can take place in the United States under certain circumstances or at your home country abroad. And the processes are similar, but also a little bit different. So if you are going through the process outside of the U.S. abroad, then the way you would do it is that you would file a petition here in the United States. And then once the petition is approved, the case gets sent out to the U.S. Embassy or consulate in the Philippines, and then your wife would be called for an immigrant visa interview. Okay, so I know you asked before a little bit about, can I get reimbursed if you ask for a tourist visa first? You can't do that. They don't provide any reimbursement. Okay, but you can definitely go the route of immigrant visa, basically applying for your wife to get a visa that will allow her to enter as a lawful permanent resident. Okay, I hope that was helpful. But please feel free to reach out to us directly. Okay. Okay, so questions about the medical exam. When do you recommend doing the medical exam for the green card? Okay, so a lot of people don't know this, but as part of the green card process, you have to show that you are admissible to the U.S. It's the applicant's burden to show that there's no reason why the applicant would be ineligible for a green card. And one of these inadmissibility categories is the public health admissibility. So in order to prove that you're not a risk to the public health of the United States, every applicant is required to do a medical exam in order to get their green card and get this medical exam done by a specific physician, a specific doctor authorized by immigration. So when do you do this medical exam? Okay, so you have to do it to get your green card, and you can do it at any time. You can file the medical exam with, you can go get the medical and file the results with your petition and application for adjustment of status, or you can do it at a later time. Just file your petition and your application for adjustment of status, and then when you get called for your interview, you can supplement it later. Okay, so it's not necessarily a requirement to submit the medical examination with your application. Okay, however, we've been starting to recommend to our clients to file the medical exam with the green card. Okay, and the reason is that immigration, USCIS here in the United States, they're starting to waive interviews when they can. The pandemic caused extreme backlogs, long wait times. I'm sure a lot of you folks can relate. We can definitely relate. Extensive backlogs. So whenever they can, they're trying to waive the interview to make the process shorter or make it more efficient. Now, if they decide that they're going to waive your interview, they cannot approve your case before they get the medical. So what they've been doing is sending a request for evidence and asking you to send them the medical examination. Now, that is all great. If you receive a letter like that, that's a good sign. That means that you're probably not going to be interviewed. However, it just prolongs the case. Since the medical is valid for 2 years, my recommendation right now is, if you can, sometimes it's not possible, but if it's possible, submit your medical exam with your adjustment of status. And if you are waived interview, then you might get your green card in the mail by surprise. So instead of getting an interview notice, you might just get that green card in the mail. So that's my recommendation for these times. Okay, I see some questions. Ava is asking, this is a really great question. Can a green card holder request a relative that's outside of the United States? A green card holder, a lawful permanent resident, can definitely petition certain family members, but they're limited on the family members that they can request. So they can petition for their spouse, and they can petition for their children. And they can petition for children either if they're minors or they're adult children, as long as they're not married. Okay, so if the children are married, they can no longer qualify for a petition by a green card holder. They would have to wait until the green card holder is a U.S. citizen to get petitioned. Okay. Also, green card holders cannot petition for their parents, which is another limitation. So yeah, green card holders can request relatives outside, but they're just a little bit limited with that. Okay. Let's see. So there's questions here about the priority dates. Will there be a change with the F3, and if getting a lawyer makes the time shorter? I wish we had the power to change priority dates, but unfortunately we don't. What happens is that in the world of family-based immigration and also employment-based immigration, certain countries and certain categories of petitions are considered preference categories. So they're not immediate relatives. They're not, they're a little bit further in the family relationship petition. They have wait times. So unfortunately, it's just, there's a quota for certain categories of visas. So this quota is decided by the Department of State, and Congress limits the amount of green cards that they can give or visas that they can give every year. So it's very limited. And like I said, every month they advertise what are the priority dates. So make sure to follow those dates. If a lawyer can't make the wait time shorter, but a lawyer can increase the chances of your case getting accepted the first time, not having rejections, not getting requests for evidence, and not prolonging your case with anything that's in your control. So I always recommend, I know I'm not objective, but specifically because I know and I've seen so many cases, I always recommend to hire a lawyer if you can. I think it increases your chances for success. Okay. Perfect. Awesome. Well, thanks everyone for joining. Like I mentioned, if you have any questions, feel free to write them in the comments. And if you are watching this on replay, also feel free to write your questions and we'll get back to you later. Okay, so I'm going to answer a couple more questions today. Let's see. Okay, so this question is, how long can I stay in the US as a tourist? I have a 5-year visa. Okay, so this question is very common because it's a really confusing topic. Okay, a lot of people get confused between the length of their visa and the amount of time that they're allowed to stay in the United States. So it's not the same. You received a 5-year visa, that's really good. Some people even receive a 10-year tourist visa. That does not mean that you can stay in the United States for 5 or 10 years. Okay. The visa basically only allows you to enter the United States, to ask to enter the United States. And I sometimes explain it as it allows you to knock on the door and ask to enter. Okay. So if you have a 5-year visa, you have 5 years in which during that time you can come in multiple times and ask to enter the United States. However, the duration of stay is something that is determined by the Customs and Border Patrol officer at the border, and it changes between person to person. So a lot of people say, oh, you come in, you get 6 months. Yes, as a tourist, usually you get 6 months, but that's not necessarily always the case. Some people get less. Some people get 3 months. Some people will get 2 months. I've seen someone get a week as a tourist. So really, the amount of time that you are allowed to stay depends on what you are given at entry. Okay, so, and how would you know? How would you know how long you're allowed to stay for? You need to check 2 places. You need to look at the stamp on your passport. So when you entered, you received a stamp on your passport, and it would say there what category of admission. So what was your type of visa? So if you had a tourist, you would probably see there B1, B2, or B2. That's the category of your admission. And you'll also see a date. And that date is the last day that you can stay in the United States. Okay. The second place you should look, and I always recommend going ahead and looking and double checking, is a CBP website, because CBP enters electronically the record of your entry. So you would be able to check and see officially what is the last day that you're allowed to stay. And basically you would be looking at your I-94 form. And maybe some of you guys remember that a long time ago, almost 10 years ago, when you came into the United States, you would get a little form. You get a little piece of paper, and that's the I-94 paper, which would say, how you entered and what's the last day, how long you can stay for. Now they digitalized it, so you would go online and you would check it. And I can grab you guys the link right here where you can check the most recent I-94, which is basically the document that determines how long you can stay for. So you just go to CBP website and ask for your most recent I-94. Okay, super important to check that out. Okay, perfect. Let me see if there are any more questions. Okay. Maria is asking, can I help my mom get a green card while she remains in the United States? Every lawyer we've spoken with says she needs to leave the country for 10 years because she came in illegally and stayed over a year. Thank you, Maria, for asking. This is such a common question, and it's such a common scenario that you're describing. So the reason why the lawyers have told you that is that one of the requirements to enter the United States, to apply for your green card in the United States, is that you've entered with a visa, that you entered legally and you were inspected and admitted at the border. So if you were not inspected and admitted at the border, you did not enter legally, you have to leave the United States and you have to process your case, your green card case, at your home country, okay, at the U.S. consulate abroad. Now, what's the problem with that? There's another law that says that if you've been in the United States for more than 1 year unlawfully and you leave, then once you leave, you trigger a 10-year bar to return. Okay. So there are certain exceptions to this rule, right? To the rule of having to leave the United States in order to get your green card. And I would encourage you to evaluate to see if any of those exceptions exist. So for example, is anyone in your family in the military? Maybe there was an old petition filed for your mom before 2001. We call it the golden ticket. The 245I petition that maybe was filed a long, long time ago for your mom or for your mom's parents, your grandparents. If she has that, then she can apply for the green card here without leaving and not have that 10-year bar. Route, for example, there are humanitarian options that might exist for your mom. So if you would like to reach out to us and have a consultation, I'm happy to evaluate your mom's case to see if there's any way we can find an exception for her that will allow her to apply for her green card here without leaving. Okay. Okay, guys. Thank you so much for joining in, for all your questions. It was such a pleasure to come out live today and answer your questions. We go live every week or so, every couple of weeks or so, probably twice a month. If you want to learn more about immigration, feel free to reach out to us directly or subscribe to our YouTube channel. We're also on TikTok and Facebook and Instagram, obviously. We'd love to hear from you. So thank you, everyone, and have a great rest of your day.